how does it help you?
No, why I'm talking about the constitutional compliance principle application of mine is legislative in character. It is not executive.
Therefore, if it is legislative in character, then can the president, even with the federal, with the presidential system of the governance that they have, will they observe that the power is with the legislature?
With all that well in place.
And therefore, the power of veto.
Please don't misunderstand me saying that your president is equated. US president, I'm transplanting him into governor's position. I'm not doing that. I'm not doing
that. Then here the case is worse off.
The reason why
the president is elected directly by the people.
No, the reason why
he can't exercise his power. Can an appointed governor who is not even can understand a president who is elected by both the houses?
No, that's why I'm trying to point out. How do we really look at Article 200 after all we have said the Constitutional Assembly debates? If the essential, the core function of the governor is to say, in the course of withholding an assent, what do they do? Is the bill constitutionally compliant? The constitutional compliance of the bill is a question presented to the governor. And what will you do with that question? Therefore, when he says that I will to find out his constitutional compliance, is it an executive function? The question which the governor will pose to himself or herself will be, how do I look at the...
Rather than supporting would be against you.
No, let me expose you on. The question which the governor will pose to herself will be, I look at the provisions of the Constitution. Does the bill comply with the provisions of the Constitution? Does it transgress the constitutional provision? Is there a conflict within constitutional provision? All those are questions which are legislative in character.
Whether the proposed law is necessary or expedient,
no,
whether it is constitutional, whether it is to be framed or to accomplish its intent, and so on, are questions all within the domain of legislature.
No, I'm not saying that you apply it entirely to the governorship. I'm not saying that. I'm only saying constitutionality. On the constitutionality, as far as the larger power of the president is concerned, notwithstanding, the constitutionality aspect of it is the essence of Article 200. That's why assent can be given if it's constitutional compliance.
Mr. Attorney, probably your argument is
yes,
that from the stage of bill to before it becomes act,
yes,
the constitutionality of a bill
yes,
is to be examined by the governor
yes,
within the framework of 200.
Yes.
After it becomes wherever the assent is granted,
yes,
and it becomes an act, then it becomes subject to judicial review.
That's right.
That is what
That's right.
wants.
But what saying, I'm talking about the nature. I'm talking about the nature of the exercise of power by the governor.
At that power which the governor exercised between the stage of bill to act,
yes,
is being constitutional in nature,
yes,
is definitely better than a legislative power.
That's right. In other words, I'm a partnership in legislation.
That's what
governor is a partnership in
legislation. That's the Leonard Solicitor does also. The governor is also a part of the legislature.
No, Article 168 puts it for certain other reasons. You may probably incorporate and probably say something about it into Article 200. I'm not saying for the time being Article 168 is the final word. But intrinsically in Article 200, I'm trying to ask myself a question, is it an executive power or is something else? If it is an executive power, then I think Article 200 will have no value at all. I have to act.
That is essentially that it's
under the
legislative power.
No, if it is an executive power, then I think Article 200.
That has been argued at length by the learned solicitor that it's an.
No, I want to point out one dimension to it. I'm not getting into all those neat questions which have already been answered. If it is taking a leaf out of the advice of the Council of Ministers, if I am right in my submission that the first proviso is entirely different, disconnected with the withholding of the assent, I think the law will look better if my recommendations are taken into account by the House. If the advice of the Council of Ministers is binding on the governor in all aspects of the 4 options under Article 200, when the governor wants to send a bill to the House, I want to make some recommendations. Will he have a recommendations in advance from the government? He will have his own recommendations. The governor will not be told, I'm giving you the recommendation, please take it as my advice.